Hello and welcome to the Rodgers Brief. I'm Adam Rodgers. Thank you for watching and thank you for listening. This is the latest in a continuing series where I read from my ebook Deficits of Trust, which is my report on the events of the mass casualty in Nova Scotia of April 18th to 19th, 2020 and the Commission of Inquiry which studied those events. So today I'm going to be reading from part 3 of that report, and the sections are, we're getting towards the end of part 3, and this is going to be section 12, which is entitled Lisa Banfield Answers No Real Questions, Avoids Criminal Charges. On the second day of proceedings, the week before the Canada Day long weekend, there was an announcement on a schedule of significant witnesses who had been subpoenaed to appear over the summer. The most notable part of that announcement was with respect to Miss Banfield. She would, in fact, be testifying, but with only one day, a Friday, being set aside for her evidence. For comparison's sake, officers whose only involvement in the events was their participation in press conferences were scheduled to testify for 2 days, while the person who lived with the killer for 19 years and spent the day with him before he went on his killing spree was scheduled for only 1. It did not bode well for an in-depth examination of their lives together, or any hope that we would get a thorough examination of what led to Wortman killing 22 people. In the midst of approximately 7 or 8 hours of available time, there would be breaks for lunch, 2 lawyer meetings to discuss what further questions should be asked, and perhaps additional breaks for Miss Banfield to gather her strength. Just as significantly, and perhaps more so, there was to be no cross-examination of Miss Banfield by lawyers for other participants. Instead, questions would need to be submitted to commission lawyers, who would decide what questions were going to be asked. Interestingly, when this was all announced, Commissioner MacDonald seemed to be attempting to deflect blame in advance for what will likely be a process that is subject to criticism. He made a point of noting, not for the first time, that commission lawyers represent the public interest and are there to ask the questions that are relevant to the MCC mandate to get to the truth. Indeed, criticism of the decision was quickly forthcoming from Patterson Law. They released a statement saying that not allowing anyone other than MCC lawyers to question Miss Banfield undermined the legitimacy of the process. This is undoubtedly true. We had already witnessed by this time the manner in which MCC lawyers questioned witnesses. They seemed to have a set list of questions from which they would not depart, nor did they follow up on answers even when it seems obvious that such follow-up would be appropriate. The MCC announcement attempted to take a glass-half-full approach to the situation. They said that, despite giving 5 opportunities to MCC staff, they think it is necessary to hear from her directly, as though the two were mutually exclusive options. There was actually no direct statement that there would be no cross-examination, but instead the commissioners, no doubt assisted by their public relations staff, said that MCC lawyers will question Miss Banfield in their role representing the public interest and on behalf of participant counsel. This arrangement is presumably the result of probably not very tough negotiations with Miss Banfield's Toronto-based lawyer James Lockyer. As I have covered earlier, the MCC did not need to negotiate this generous arrangement with Miss Banfield. She had no real leverage vis-a-vis the MCC, as she could simply be subpoenaed and then subject to cross-examination. Her leverage was with the RCMP, who had breached her charter rights in their improper questioning of her. Commissioners more experienced in managing a courtroom may have decided differently and been comfortable allowing questioning by all parties, limited only by relevance. The fact that she was not going to be cross-examined may have seemed to suggest that the one lawyer asking questions might go tougher on her, but as it turned out, the trauma-informed motivations behind the decision led to a series of soft, predictable questions, with any and all answers being uncritically accepted. In the days before she testified, there was a foundational document presentation of Ms. Banfield's statements and reenactments. We heard her recorded voice and also saw her on video, reenacting portions of her account of events. This was as close as we got to having Miss Banfield testify about the events of the mass shooting. The Commission had already decided that she would not be retelling her experience of violence. when she was to give evidence. In my view, this is similar to the problems with the earlier testimony of the police officers who first arrived in Portapique. Rather than having a lawyer for the commission give a presentation of the statements and evidence, it would have been much more powerful to have Miss Banfield go through her story with the aid of the audiovisual elements of the foundational document presentation. I also think it would have been better for her public reputation to do so, rather than being hidden behind these protections. She was able to endure lengthy interviews and reenactments, so it seems likely that she could have handled live questions and respectful cross-examination. This is indicative of the MCC's instinct to seek total control over the narrative of the events of the mass casualty. To help understand how they think, consider their response when Global News asked the MCC why no members of the Wortman family have been called to testify. The answer given back was that while the MCC could subpoena witnesses to testify, they could not force someone to submit to an interview in advance. And that since Wortman family members did not agree to a pre-interview, the MCC decided not to call them as witnesses. The possibility of a surprise answer of any kind overwhelmed, in their view, the chance to learn something about the killer. This was an example of how the MCC saw actual live testimony with cross-examination as secondary or optional, rather than central as it would be in most judicial proceedings. It also demonstrated their desire for total control over the narrative that was being presented publicly. Testimony can be unpredictable, particularly when no pre-interview has taken place. It suggests that they have predetermined the outcome and do not want to risk anything affecting the central narrative that has been developed. Miss Banfield was not cross-examined. A decision from the MCC which prompted Patterson Law and MDW Law to boycott the proceedings process of questioning her. The MCC lawyer was going to ask all of the questions, and other lawyers were to be given an opportunity to submit questions. The lawyers for the family participants rightly decided not to legitimize this process through their participation. All of this was a mistake by the MCC, Miss Banfield, and the RCMP. Pieces of evidence supporting Miss Banfield's account have been discovered, such as her sneakers, which she has stated Wortman threw away and were found, and the tree where she claimed to have hid overnight, which was shown on a video, and which stands out as a large fallen tree among many much smaller trees which typify the area. More medical information may have counteracted some of the earlier statements suggesting that she suffered few injuries. It would have saved everyone considerable trouble for this evidence to have been publicized early on in the aftermath of the shootings, and for Miss Banfield to have spoken out publicly in the early days rather than waiting. Whoever has been advising the MCC and Miss Banfield on these points have caused their clients considerable unnecessary grief. The instinct to secrecy and the instinct to micromanage the narrative are what will remain as permanent critiques of the RCMP and the MCC, no matter how much evidence later comes out to counter any theories. Those who have propagated these theories have not been making things up with no foundation. They have relied on statements, gaps in evidence, and the natural suspicion one should take in the face of institutional secrecy following a major public event. Lisa Banfield did give evidence from the witness table. She was supported by her two sisters who sat on either side of her while she spoke. There were many questions one might have imagined asking Miss Banfield. Some were factual about her movements during the night of April 18th, 19th, 2020, and some about her actions in advance of the killing spree. Most went unasked by Gillian Nattau, the MCC lawyer given the important responsibility of questioning Miss Banfield. There was significant pressure on Miss Nattau, and I was surprised not to see lead counsel Emily Hill in that position. There was a delicate balance to be maintained. On the one hand, she had to take a respectfully restrained approach that would be considered appropriate in light of Miss Banfield's status as a survivor of domestic violence. At the same time, she had to demonstrate a willingness to apply a degree of probative pressure to the witness as a means of justifying the decision to not allow cross-examination. What we saw was almost entirely the former. She should have asked about the terms of Miss Banfield's restorative justice referral, whether she completed it or them, and whether this testimony is part of that agreement. She should have been asked more about what she knew about the capabilities of the replica car and whether she ever considered the potential danger of its existence, and what she knew about his access to weapons and ability to get them across the border. This last piece would have been particularly helpful, as the ability to get those guns across the border was the primary reason Wortman was in possession of such an arsenal. It seems like she may have known more about his weapons than she was thus far revealed. In her April 28, 2020 police interview, for example, Miss Banfield alluded to Wortman throwing something at the truck in which she first hid to blow it up, suggesting she knew he had grenades, knowledge she has denied. Then, later in that interview, she was talking about the cross-border smuggling activity when Staff Sergeant Vardy seemed to purposefully steer her into a place where she denied direct knowledge of how Wortman, a Nexus holder, was able to get guns across the border. She admitted only overhearing things or getting snippets of information from Wortman. As to the events, she could have been asked to explain things like why she thinks her coat was not found, despite her saying it was thrown in the woods adjacent to a path, whether the size 8 slippers found in Debert next to other items from Wortman's car were hers, and whether she had any thoughts on why Wortman made the very risky, from his perspective, if he had extensive plans to carry out, decision to not pursue her further and instead move on to others. Then, I thought it would be important for people to hear how and when she learned about how many people were killed and started to appreciate the scale of events, what she thought about it all as she tried to piece it together, and why she has not spoken out publicly about what has taken place. Unfortunately, when Miss Banfield actually testified, there was no mention of her restorative justice conditions, no real insight into why Wortman killed all those people, and no clear sense from her that she had thought about why he did not try harder to kill her before leaving Portapique. Her answers were short and seemed designed to avoid prompting follow-up questions so that she could just get out of there. She also seems to be trying to protect her civil claims to Wortman's $1 million-plus estate. To do that, she needed to establish two things. First, she needed to show that she was effectively a co-owner of the denturist business, not just an employee. That would mean that she was entitled to a share of the profits from the business. Secondly, she needed to reinforce the notion that she did not have any inkling that he was planning a mass shooting. That would mean that she bore no personal civil liability towards the victims. You could see the legal strategy that had been developed for her unfold. She spent time early in her testimony talking about how skilled and efficient she was at work, and how she was often running the operation on her own while Wortman was away or otherwise occupied. Then, she talked about how he was often away in Portapique on his own, and she had no real idea what he did there or who his associates may have been. It became clear soon after this minimal testimony, Miss Banfield was on the stand for a total of 3 hours, was delivered that doing so was the one and only condition of the restorative justice agreement that led to her criminal charges being dropped. On July 19, 2022, a Crown prosecutor informed Provincial Court Judge Ted Tax that Miss Banfield had completed the restorative justice process and that the charge against her could be dropped. Often a judge will ask the Crown or be told by the Crown or defense lawyer what the conditions of restorative justice were that were completed. This can help the public understand what kinds of things are done through this restorative process, and so provide a sense of what everyone involved considers to be a just outcome. Here, the Crown did not say, the judge did not ask, and nobody from the MCC seemed inclined to discuss the matter. Given that there were no cross-examination questions permitted, none of the participants could ask Miss Banfield either. Miss Banfield's brother James Banfield and brother-in-law Brian Brewster had their charges dropped as soon as Miss Banfield testified as well, so it would seem that all of the matters were tied together. This leads me to conclude that the Crown realized it had no case against Miss Banfield, and that the other charges were derivative of hers. In other words, the evidence to charge the other two came from information gained through the police statements made by Miss Banfield, which were unusable. Not only did the police violate Miss Banfield's charter rights when they failed to advise her of her right to silence and right to consult a lawyer, it seems they might have done the same with Mr. Brewster, given his defense lawyer's comments to the media when he originally pled not guilty to the charge. Miss Banfield's lawyer, Mr. Lockyer, in his only appearance in the MCC, asked Superintendent Campbell whether he was aware of an RCMP strategy, which I took from the question must have been included in Miss Banfield's criminal disclosure, to not give Miss Banfield, her brother and brother-in-law their Section 10B charter right to speak with a lawyer before being questioned. Superintendent Campbell was not, which Mr. Lockyer likely knew, but the point of asking the question was to let the commissioners and public know that such a highly improper strategy existed. This last series of questions confirmed to me what I thought must have been the case about Miss Banfield's charges after I read her interview with Staff Sergeant Vardy, where very late in the interview he started giving her a paraphrased version of a charter warning. This all means that none of the three would likely have been convicted of the crime, as any statements they gave and any evidence derived or discovered as a result of those statements would have been excluded from their trials. Nobody from the RCMP or the MCC has directly answered for these elements of the investigation. MCC really wants you to know it cares about domestic violence. In the lead up to Ms. Banfield's testimony, the MCC consciously set the stage for her by hosting multiple panel discussions and presentations focused on domestic violence and intimate partner violence. A great deal of work seems to have gone into assembling these panel discussions, which seem to have little resonance in the public, but which seem likely to form the basis of much of the Commissioner's ultimate recommendations when the report comes out March 31st, 2023. One can expect that the final report will identify that domestic violence is underreported, that bystanders and police officers need to take more responsibility when it comes to identifying situations of violence, and that more resources should be directed to support victims. It would be interesting to be able to parse out how much time and MCC budget resources have been directed to these discussions. Full-time research and policy directors were employed by the MCC. Academics from universities and institutions from across Canada, the United States, the UK, and Australia have all been commissioned to prepare reports for the MCC, which must have a direct cost. No doubt the research and policy people at the MCC have spent time examining each of these experts and academics prior to hiring them to prepare reports, and have perhaps gone beyond that to study other experts who have ultimately not made the cut. It raises questions as to the role of the commissioners and the use of the limited time allotted to the MCC. In a civil trial where an issue arises that might be beyond the expected knowledge or intuitive abilities of the presiding judge, an expert, or often two competing experts, may be brought in to shed some light on the matter, after which the presiding judge uses their analytical skills to make a determination about the specific situation before them. Here, there were several dozen experts brought in to speak about the issues around domestic and intimate partner violence. The MCC was seemingly trying to cover the entire possible spectrum of issues on these topics, regardless of whether there was a connection to the events of the mass casualty being studied. There are two possible presumptions behind the heavy volume of expertise on the issues of domestic violence. One is that it is an area of study that is so unintuitive that these three commissioners could not possibly come to their own conclusions, and so required this high level of guidance in order to understand what is happening and what needs to happen. That strikes me as a very low level of expectations to have for the three supposedly highly qualified commissioners. The other possibility is that the time spent was seen to be somehow valuable in educating the public on issues of domestic and intimate partner violence, and that this will help address the identified issues around public attitudes around such violence. If that was the goal, the low level of public engagement on days where these panels have been featured would suggest it was an ill-conceived objective. There was limited time for the MCC to do its work and prepare a report with persuasive recommendations. Each day that was used for a discussion panel to aid the commissioners or educate the public was a day that was not used to examine witnesses or deal with issues such as cross-border smuggling or criminal intelligence capabilities. These are all choices that the MCC made. In her introduction to one such panel discussion, Krista Smith from the MCC noted that these discussions were designed to set up the discussions which are anticipated to take place in Phase 3 of the MCC proceedings, where potential recommendations would be formulated. This seemed to be a hopeful sign that the many experts who have been retained by the MCC would actually discuss the events which have led to the establishment of this inquiry. But that turned out not to be the case. There was never an attempt to build a compelling case that these killings were caused by domestic violence or that IPV was a central feature of Wortman's motivations. The experts one morning, for example, called for major paradigm shifts, full system changes, and tearing down the system as evolving solutions to the issues we are facing. Those views applied to the police and the justice systems more broadly. It is not always clear how these suggested overhauls are supposed to manifest themselves in real life or in clear, specific language. Collaborative police action sounds like a good phrase for combating domestic violence, but is open to many potential interpretations to the point of being effectively meaningless. The sheer volume of time used to discuss these issues of violence would suggest that this has been determined to be the most important causal element of the April 18th, 19th, 2020 mass shooting, and perhaps also that it is an area where meaningful change can emerge from the MCC process. It is not clear to me in observing the evidence that has been tendered and then the final submissions from the participants that either of these possible determinations are accurate. The discussions were emotional for the speakers at times, as they described many stories of abuse suffered by women in a wide range of circumstances. Discussions covered women suffering abuse who were also struggling with racism, their precarious immigration status, drug addiction, sex work, and rural living. There was a long discussion on the difficulties of rural women in abusive situations. There may be transportation issues, and then there are other practical issues as well that you might not consider in the city. In a rural area, for example, if your car is parked at one of the few law offices in town, someone will see. The police officer to whom you report may be in your church. Your abusive spouse may be a respected coach. Issues of child custody were raised in terms of abused spouses trying to protect their children and in terms of concerns of family courts favoring the spouse who is seen to be in a more stable situation with an income, home, and support network, factors which may not favor a woman who has left a home and is in less than ideal living circumstances as a result. Again, those are relevant issues in their own right, but not for an analysis of the Gabriel Wortman-Lisa Banfield dynamic. She lived in urban Dartmouth, had potential access to large amounts of cash and at least one vehicle, had supportive family members, had no children to protect, and was not part of a marginalized community in the senses discussed by the panelists. It is also not clear that domestic violence or any issue having to do with Miss Banfield was what prompted Wortman to burn down his properties and kill 22 people. There were property disputes, overdeveloped COVID-19 concerns, and an underexplored and potentially complex relationship with police and criminal organizations, which also may have sparked his killing spree. Those matters have received comparatively little attention from the MCC. The speakers during one panel had a long discussion on a Nova Scotia case, but it was not that of Gabriel Wortman and Lisa Banfield, but rather that of Nicole Doucette and Michael Ryan. Miss Doucette was the victim of abuse at the hands of Mr. Ryan, and was then the victim of an RCMP sting operation when officers contacted her in the guise of a hitman offering to kill Mr. Ryan. The case went to the Supreme Court of Canada after Miss Doucette was acquitted at trial on the basis of a duress defense. Interestingly, Commissioner MacDonald was on the Nova Scotia Court of Appeal panel which upheld Miss Doucette's acquittal at trial and was the main author of the well-reasoned decision. Supreme Court disagreed with the expansive definition of duress adopted by then Chief Justice MacDonald, but held that it would be improper to subject Ms. Doucette to another trial and stayed the charges. One of the ideas discussed in at least two of the panel discussions was to criminalize coercive control. This was suggested by Lakehead University's Dr. Laurie Chambers, though other panelists cautioned that it might be risky to expect an unreformed and problematic justice system to properly address the complex issues around coercive control. Other experts tended to support something akin to a public health approach to the problem. Another panel dealt with the topic of police and institutional understanding and responses to sexual violence and other forms of gender-based violence. The discussion included Emily Coyle, Executive Director, Canadian Association of Elizabeth Fry Societies; Lana McLean, a clinical social worker, co-creator of Impact and Race and Cultural Impact Assessment; Sunny Marner, National Project Leader of the Improving Institutional Accountability Project; Deepa Mattu, Executive Director, Barbara Schiffler Commemorative Clinic; Dr. Pamela Palmater, Professor and Chair of Indigenous Governance, Toronto Metropolitan University; and Professor Isabel Grant from the Peter Allard School of Law of UBC. The early portions of the discussion involved a review of the basic elements of criminal harassment and consent in the modern legal context. It is unlikely that any reasonably educated or experienced adult would be surprised by any elements of this discussion other than the notion that someone thought the discussion was needed at the MCC. There was further discussion of the myths, stereotypes, and inherent biases that affect women, viewed both as a whole and aimed at minority women specifically. These myths, stereotypes, and biases persist despite years of efforts by these women, the organizations they lead, and many others. One of the last panels featured a discussion on IPV, GBV, and family violence, personal and community responses, and featured Pamela Cross, Legal Director, Luke's Place Support and Resource Center; Dr. Deborah Doherty, former Executive Director of the Public Legal Education and Information Service in New Brunswick; Emma Halpern, Executive Director, Elizabeth Fry Society of Mainland Nova Scotia; Professor Janet Mosier from Osgoode Law School; Lorraine Whitman, President of the Native Women's Association of Canada; and Dr. Rachel Zellers from St. Mary's. This represented the 8th MCC discussion focused on domestic violence. Several of the panelists referenced the previous panel discussion, stating that they supported the submissions made so far. It is noteworthy that this panel, like every other IPV-GPV discussion held by the MCC, was made up entirely of women. I noticed this first as an observation rather than a critique following the first couple of discussions. As we went further into these topics, however, it seemed time to ask whether it may have been better to have a wider variety of expertise in terms of gender. I noted above that I think there had been too much total expertise focused on these topics, but if we were going to have up to 10 independent discussions on family and or intimate partner violence, it might have been good to hear from both genders. It seems that the NCC was intent on making domestic violence a central part of the narrative rather than having it emerge naturally through the evidence. This was exemplified in part by their choice of experts, Tristan Bridges and Tara-Lee Tober from UC Santa Barbara, for an earlier, more broadly based discussion on mass casualties. They were asked about the definition of mass casualty. In their view, that definition would include acts of domestic violence, but they acknowledged that these views were outliers among experts in their field. In other words, the MCC sought out and brought in experts from California who would give them an opinion that fit with their apparently preconceived narrative. Many mass shootings include domestic violence or even familicide, and we heard that 30% of mass shootings targeted women. What we never heard during the MCC was whether this mass shooting targeted women, or whether there were other times where a spouse had their life spared under circumstances similar to Miss Banfield. We also did not get a clear sense that there is agreement on what might specifically be done to significantly lessen the numbers of domestic violence incidents in Nova Scotia. The public health approach seemed the most promising, with less focus on criminal processes and consequences and more on strengthening relationships along with family and community well-being. All right, those are two longer sections, so we're going to close it there for today, just under half an hour. So again, thanks everybody for watching and thanks for listening. I think we have probably one more video to finish off the ebook, so look forward to recording that in the next couple of days and I'll post that for you very soon. So Thanks again for watching. Thanks for listening, and we'll see you next time.